My name's n.bennett. I'm from Cleveland Patent and Trademark Attorneys. I'm mainly on the patent side, but we also deal with a lot of trademark work as well. Can you all hear me okay? Yeah. Right, so what we want to cover today, we're going to go through the types of intellectual property protection that is available, how you can go about obtaining those different types of protection, and also, you know, given where we are, with a kind of an eye on overseas protection for your IP. So just kind of stepping back a little bit, the kind of IP landscape today, there's quite a lot of political interest in it. That there is a quote from, I think it's from the Hargreaves Review, but it's basically highlighting the kind of the large amount of investment that there is in intangible assets. I don't know quite how they've calculated the £65 billion number, but I think the take-home message is it's a big one, and if there's that much investment, then it's legitimate to ask whether it's worth protecting that investment. So there's the Hargreaves Review was a review into kind of updating the IP system. There's been various improvements made because of that. For example, the patent box system, which I'll come on to in a little bit, which is a tax break for businesses selling patented products. And the IP Act 2014, which kind of tweaked all the legislation and it just improved various bits of the law to do with registered designs, a bit of the patent stuff as well. So that's kind of where IP's going today, or where it's at. This is starting reasonably basic. There's four main types of IP, and there's a different legal framework that gives rise to each of those. So the four main types are patents, trademarks, designs, and copyright. And we'll come on to what each of those is intended to protect a bit more, and how you might go about registering for that protection if required. But I think the question that he's asking first of all is, why bother with any of this stuff? Why bother protecting IP? One reason is that exclusivity is valuable. If you're the only one in the market that can supply a particular product, you can charge higher profit margins, obviously. An IP can give you that exclusivity. It can be a source of revenue. So if you have IP in areas which you're not well equipped to kind of exploit straight away, then you can license that IP to other people who might exploit it and give you a royalty from that IP. It's good for attracting investment. Even if you can't enforce your IP, it's a way of crystallizing value and showing investors something concrete, which would otherwise be kind of completely hand-wavy and kind of intangible. And it's also a way of protecting your brand, which we'll come on to a bit more with on the trademarks side of things. So let's go on to patents, which is my main area that I deal with. So patents, what are they for? They're for technical inventions. Oh. Yeah, and it's a monopoly right. So the idea is that you can stop other people from using your inventions. And that monopoly lasts for 20 years, generally, and is granted by a state, or let's say the patent office of the state, who are over there, or a non-governmental body, for example, the European Patent Office. So what's it actually allow you to do? Well, a patent doesn't give you rights to do anything. It doesn't give you the right to go and sell your product. For example, you could come up with a highly inventive explosive. It doesn't give you the right to do that. It might be illegal. It doesn't give you the right to go and sell your drug that you've come up with. What it does do, and an example of that is, for example, if you come up with an improved type of spark plug, you get a patent on it. It doesn't give you the right to go and sell that spark plug. For example, you might infringe somebody else's patent on a combustion engine per se. So in order to work your invention, you would need a license from them, and for them to work your improved spark plug, you'd need a license. They would need a license from you. So it's not the right to do anything, and it doesn't give you freedom to operate, but it does allow you to stop others from doing all of those kind of commercial acts, which basically encompass everything that would enable somebody to make money from your invention. So you can stop them from selling it, you can get court orders to stop them making, using, or offering to use your product. And what can you do if you think people are infringing your IP? Normally, and this is the kind of preferred solution, you'd get some kind of settlement deal before it went to court and avoid all that expense, and hopefully they would take a license to your IP and you'd get some royalty or lump sum payment because of that. But if it does go all the way to court, you can get a court order, an injunction to stop people from importing stuff, making stuff, selling stuff that falls within your rights. You can also get damages to put you back in the position that you would be had the infringement not occurred. So if someone's already sold a shipping container full of stuff, you can get damages to put you back in the position you would have been in had they not done that. And you can also get an account of profits as an alternative to damages. So you could take a cut of their profits from sales that have already occurred. So that's the kind of the reasons for doing it and what you get from patents. But in order to get a patent, it's not the easiest thing. You've actually got to come up with some sort of invention that you can argue is novel and inventive. So this is something that we've been dealing with. It's a little drug delivery microsphere. So these things are kind of, you can see from the scale, a few microns across, and you inject these into your vasculature soaked in drug. So they sit in the vasculature next to a tumour, releasing drug, and also kind of embolizing to stop blood getting to the tumour and feeding the tumour. So this is, before our client came along, this was the prior art. So this was already known, and the idea of injecting things like I just described. So you might think, well, there's nothing new about what we've done. But then you actually have to identify what is the advantage that is provided by what you've done. And although we are using that known kind of injection technology, what our client managed to do was to find a way of producing these microspheres which gives you a really interconnected pore structure on the inside. So it soaks up more drug, releases over a longer time, and therefore, the treatment is much improved. So a lot of what we were trying to do was focus on how do we protect the internal pore structure. So although that's kind of nitty-gritty detail, the take-home message is, even though the kind of broad invention, you think it might have gone, it was already out there, if you're making even small improvements, you can still get really useful patents which cover those. And they've spent a lot of money trying to defend this before the European Patent Office, and especially in the pharma field, even narrow rights are pretty useful. So what's a patent application look like, and how do you define what the invention is? Well, you have a set of claims which are numbered statements, and they set out in words the scope of the monopoly that you're asking the patent office for. And that's what we as patent attorneys spend most of our time drafting and arguing about the wording of these things. And it's the claims that have to define something that is new and also inventive, and we'll come on to how those things are assessed in a second. So you'll also have a description which just sets out, teaches the skilled person how to work the invention, and if you don't teach well enough how to do it, your patent might be invalid. And in order to do that, you might also need some drawings to further explain, and you'd have an abstract which is just used for searching purposes. So you can look at a patent database, just analyse the abstract and figure out whether that patent is relevant for you from a kind of freedom to operate perspective. So this is a kind of trivial example of what a claim looks like. So the invention might be on the left. It's this new kind of double-headed paperclip that somebody's come up with. And then you have to set out, well, we have to set out what exactly the invention is. So we try and incorporate all the essential features necessary to get the advantage that the invention provides, but without incorporating any kind of superfluous features. So you'll notice there's only kind of a common section, a first clipping section, and a second clipping section, and that's all you need really to define that high-level invention. You don't have to kind of specify that the clipping section's a spiral or whatever. So you're trying to focus on the inventive concept rather than the specific embodiment of how that is done in practice. And the reason for that is that when a court comes to assess whether somebody infringes your patent, they'll look at the claims and they'll say, does the infringement have all the features of the claims? Yes, it does. So if it does, then it infringes. If you've got lots of superfluous features in, like you say, oh, the clipping bit has to be spiral, then somebody could come along. If theirs isn't spiral, they could still get the technical effect and work around your patent wording. So it's really crucial that when we're drafting claims, the wording that you use is correct and gives you the scope of protection that you're entitled to. And as a patent attorney, that's our job. And in a kind of chemical context, you might have a kind of backbone structural formula, and then lots of different R groups which define various substituents that you think would give the technical effect. And you get a broad scope of protection by only specifying certain of those groups and giving lots of options for those groups. So that's how we define chemical inventions, really. Okay, back up to kind of high level, or things that apply to all sorts of different patents. So in the UK, you file your application at time equals 0. After 3 to 4 months, you get a search report from the examiner. So they will go away, look at your claims, and do a search to find any prior art that they think is already published and is relevant to your application and is useful for assessing whether your claims are novel and inventive. And it's at that point that you really figure out whether your patent has a good chance of being granted or not. After 12 months, you have a deadline for making any foreign filings. So if you're looking for overseas protection, you have to do it within 12 months in order to retain your earlier filing date for all of the foreign applications. Because patents are completely territorial. If you have one in the UK, it doesn't really let you stop somebody from making your product in the States or whatever. So that's a consideration to be made in the first year. After 18 months, the application becomes published. It will be officially published by the Patent Office. That's when your competitors can see what you're doing and what you're trying to get granted. After that, it will be subject to kind of formal examination, and the examiner might come up with objections saying it's not novel, it's not inventive. Then you can go through rounds of amendment of the claims or argument. So we would normally argue on our client's behalf and say, actually, the examiner's kind of misconstrued this piece of prior art, and we are novel because for these reasons, and therefore we should be granted a patent. And at a maximum of 54 months, your application needs to either be in order for grant or, it will be withdrawn or deemed abandoned. So that's a kind of timescale, and that might look kind of scarily long, but the kind of process can be condensed an awful lot if you need a granted patent quicker. For example, if you're aware of an infringer, whatever. Okay, so I mentioned the prior art there and how the novelty and inventiveness is assessed against the prior art. So what is the prior art? It's everything that's public before the application is filed. So that includes written disclosures, oral disclosures, who you tell down the pub, commercial discussions perhaps if they're not under a duty of confidence. They might also be considered public, and also prior uses. So if you've gone out and sold your product and the people you've sold it to are free to go and examine it, then your product is disclosed, and that would destroy the novelty of your patent application. So this is the front page of a published patent spec, and you'll see on the left there's a list of cited documents, an abstract, patent number, and a kind of this groundbreaking invention was for a kind of doggy doorbell. Okay, so the dog rings something and the owner knows that he's trying to get in. But the examiner's gone away, done his search, and he's cited a few patent documents there at the top, the GB numbers, but he's also cited the BNO. So this shows the kind of all-encompassing nature of prior art. The BNO is published, it's publicly available, and if you go to that particular issue of the BNO, you can actually see that somebody has come up with the idea of having a doggy doorbell before, and like the dog in the BNO's using it. Okay, so that's the prior art against which your kind of claims will be judged. This is a timescale for foreign protection. So as I said, it's 12 months from the UK filing date, and it's at that stage that you have to kind of decide whether you're going to go into Japan, China, whatever. And if you file within that 12-month period, the filing date of all of these applications will be backdated to your original UK filing date. And that's useful because if you publish your invention within that 12 months, if you didn't have that backdating process, your disclosure would be prior art against all of your other applications, and it would render them not novel. So by backdating within 12 months, you make sure that any previous disclosures of your own are not prior art. So you can file individually in all of those countries at that 12-month stage, or you can do what's called a PCT application, which is an international patent application, and it basically just defers, it keeps your options open to pursue essentially any commercially important territory around the world, but it defers the time at which you need to choose which countries ultimately you proceed with. So it defers the time where you have to split it off until about 30 months from your UK filing date, instead of having to do it after 12. So it's a good way of deferring costs, keeps your options open, and generally that's what our clients will do. So, in terms of costs, these are pretty ballpark, but normally we estimate around £3,000 to £5,000 to draft a patent application and file it at the UK Patent Office. And the way that that's billed is, well, the way that we charge is on a time spent basis, so that's for time spent in putting together the claims, the description, reviewing any prior art that you might be aware of, and then figuring out what scope of claims we hope we can get granted. It might be $4,000 to file after that 12-month stage in Europe or the US. And there's various other costs around the world. So China's expensive because you need translations. Same with Japan, but those costs are generally incurred at a later date. And there's also prosecution costs once filed. So a European application will undergo its own examination, and the examiner in Europe might raise different objections to the UK examiner. So that's something to budget for. So this is my last kind of patent slide. It's just really to flag up that the UK patent box exists. So the patent box is a tax break. Normally you pay, I don't know what it is, 23% corporation tax, I think. For the patent box you pay 10% corporation tax on sales which are derived from patented goods, providing that you have a qualifying patent, which is normally a UK or European patent. But providing you have that UK patent, the patent box or the tax break applies to worldwide sales. So even you've got a UK patent, even your sales from the States will still be subject to that lower rate of tax. And there's a deadline coming up, which is June 2016. The system is being slightly watered down because I think the Germans have complained that it's a kind of mechanism for profit shifting. So it's being watered down, and to get into the current regime, which is probably more advantageous than the one that's about to come in, the deadline for getting your patent granted is the June 2016. So get your applications in now. That's my advice. Right, coming on to trademarks. So patents for kind of technical inventions. Trademarks are basically to protect your brand. So probably much more widely applicable to all businesses if you generate some kind of goodwill from your customers. So what is a trademark? It is something which is graphically representable, which in the consumer's mind alerts them to the origin of your goods. So it's an indicator of origin, and that is something that you might want to protect. So you would file a trademark registration for something that's graphically representable, but it's limited to particular classes of goods. So I've got some examples of classes of goods. So you might find in class 12 for vehicles, class 35 for advertising services, and then you would be able to enforce your rights generally only in those classes, although there is scope for trying to kind of broaden the scope of protection. And the term of these things, unlike patents where you've got a limited 20-year monopoly, trademark rights, providing that you're still using the mark and the brand, can be indefinite. So providing you pay the renewal fees, these things just keep existing. So it's quite a powerful right. And as with patents, there's kind of national and regional rights, so you need to apply where you want protection, where you think your important markets are. So what does registering your mark actually allow you to do? Well, it can deter other people from using your mark or marks that are confusingly similar. And I'll just come on to that in a second. It's easier to take legal action if your mark is registered, and it's also a lot easier to license or assign with a part of the business if it gets sold or whatever, if you've got that trademark registered. So as I mentioned, you can stop others if you've got this registration from using either a mark that is identical to your mark or one that is similar to your mark, providing in the course of trade, providing that the goods or services for which they're doing it are similar to the ones you have your mark registered for. And it's usually in cases where confusion in the mind of the consumer is likely. And what can you do? The remedies for infringement are essentially the same as patent. So you can get damages, account of profits, injunctions against people using your mark. So what do you need to get a trademark registration? Well, as I said, it's got to be capable of being graphically representable, I guess. It must have distinctive character, so it can't be descriptive of the goods that you're offering. And it can't be generic, so there's some stories. So I think escalator used to be a trademark, but it's become generic, and therefore the trademark rights will now have lapsed. And I know Xerox had similar problems with their mark. So these are some of the things that you might want to register. You can register word marks, and that includes domain names. And you can register them with the word itself per se, and that is what, you might register Cleveland for intellectual property services or whatever, and that's the kind of most common one that people know about. You can also try and get slogans, although it's generally harder to get. So you've got these ones. You need to show that your slogan has acquired distinctiveness for a particular class of goods. So you might recognise the top one as Gillette, best a man can get. Mr. Kipling was registered in '84 as the word mark, easy to get registered, because it doesn't relate to cakes at all. Exceedingly good cakes, they had to wait until 1994 until they'd accumulated that kind of goodwill and reputation in the mark, so that it had acquired distinctiveness in the field of cakes before they could register it. So you've also got the kind of, I think trademark attorneys will call them device marks, so the logos, which you will be familiar with. And then moving on to some of the slightly more obscure ones, so you can register trade dress. So I'm not sure the registration number, but I've got it on good authority that the idea of putting a lime in the top of a beer bottle is registered by Corona, or whoever owns Corona. Product shape, like the shape of a Toblerone, if there's distinctiveness in that, you can get a registration on that. And you might have seen in the news, Cadbury's have just failed to get the Kit Kat shape registered. So you need to really show that there's quite strong distinctiveness in that shape. And the Coke bottle is registered as well, I believe. Sound marks, surprisingly, the lion's roar you see at the cinema when you go in, that is a registered trademark, because you can represent even the roar as a kind of a soundscape. And if you've got any musicians, you might be able to tell me which one that is. No, that's the Direct Line theme, which you'll know, but I'm not going to sing. So you can get sound marks. So colours, this is really kind of pushing the boundaries of what you can get registered, and obviously trademark offices and the courts are kind of reluctant to give monopolies in colours for obvious reasons. People need to be free to use colours, but if you can demonstrate that a particular colour has acquired that much distinctiveness for a very narrow set of goods, then it is possible to get them registered. So that orange you might recognise as Orange Mobile Communications, and you'll find that with these marks it's very specific what exactly that orange is. So it's a particular Pantone for a very narrow class of goods. And also BP Green, they managed to get that registered for the outside of filling stations. So if you think those are really important parts of your business and you want to stop people driving into service stations that they thought were yours, which weren't, then that might be something to register. Okay, so patents for inventions, trademarks for protecting your brand. Copyright is a slightly different legal framework which protects literary, dramatic, musical and artistic works. So it will subsist in things like code, software, computer code, the copy that you have on your website, your marketing materials and things like that. And also, if you're in the music industry, it's obviously important for you for musical works and recording rights. So the term of copyright is 70 years after the author's death. Unlike trademarks, which are in theory unlimited, and patents, which are limited to 20 years. So that seems like quite a large scope of a large term of protection. But the kind of plus point is that copyright subsists anyway. You don't need to get it examined, or you don't need to file at any patent office. And what you do doesn't even have to be any good. Copyright will subsist in, any old song that I make up, which is not going to be good. Oh, I thought you were looking at that already, but that's essentially what I've just said. So you can stop people from infringing on your rights, even though you've not actively gone and registered them, providing you have some sort of evidence that copying has in fact taken place. So to prove infringement, you need to prove that someone's had access to your work and has actively taken a substantial part of that work. And the substantial test is obviously, it will differ from case to case. There's no hard and fast rules about how many words you can take or how long your sound sample can be. It's whether a court thinks that the taking is substantial or not. So that's primary infringement, but you can also be sued for secondary infringement, so dealing in infringing works and facilitating copying. So it's not just the person that has had access and actually done the copying itself. It could be someone perhaps that is subcontracted to print a load of infringing literature. And there are various defences for copyright, so things like I was doing it for research or private study, criticism or review, reporting of current events, and there's a new defence which is parody. So it's not quite clear what you have to do to show that you're making a parody of something, or whether it has to be funny or not, but that is now a defence to copyright infringement. But it's not really something we deal with super regularly, because it's something that you end up arguing about when you're aware of an infringement, rather than doing the registration process up front. So coming on to registered designs, or designs in general, this is to protect the kind of aesthetics of your product. So I'm not sure if the Barcelona chair is registered, but the aesthetics of that are pretty famous and probably has been registered at some point. So that's what registered designs are there to protect. They're not there to protect the function, but they're there to protect what it looks like. And generally there are two types of design rights. So there's registered designs where you go to the patent office, you try and get a registration, and there's unregistered designs which are more like copyright. And the advantage of registering it is that you don't have to prove that somebody has actively copied it. Whereas if you're relying on unregistered rights, you need to show that someone's had access. So registered design rights, although it does cost a bit of money to register them, perhaps £1,000 to get a European-wide one, it's a lot easier to enforce, and you don't have to show that someone's actively copied you. So what can you protect? It's the appearance. So that means this is what the law says: the whole or part of a product resulting from the features, lines, contours, shape, blah blah blah. And a registered design protects new designs which have individual, i.e. individual aesthetic character, and they last for 25 years. And it's the overall impression of the design which is important. So you just file a picture of it at the patent office, and if someone else's product gives the same overall impression, you might have a good case for that they've infringed your design. So we're going to I think I'm running out of time, so we're going to zip through a few things that you might be able to register the design for. So you recognise that one. Obviously, shape of your product, that's kind of aesthetically nice, or it used to be. Apple can register that. So you can register packaging, which they also did. The Febreze squeezy thing, air freshener packaging, that was the subject of a registered design case in the UK courts. So you can also register slogans and graphical type things as an alternative. If you can't get a trademark, you might still be able to get a registered design. User interfaces, eBay have registered that one. Typefaces, that's a Nokia font that they've managed to register. And there's another user interface for you. And then this is an Apple registration for the iPad on the left, and the allegedly infringing Samsung tablet, which this has been litigated in the UK courts, and it was actually held that this allegedly infringing product didn't fall within the scope of that registration, so that the scope of the registration was actually quite narrow in that case. But the scope of the registration depends on kind of how groundbreaking your design is, so it doesn't necessarily mean that it's always very narrow scope. Okay, I think this is last couple of slides now. Foreign protection is available for designs as well. You can file under the Hague Convention to get lots of different countries in one registration. And you need to file, unlike patents where you have a 12-month priority period, it's only 6 in designs. And you can see that you get lots granted, not many refused. It's easy to get designs because they're not actually examined. So what can we do for your business? I think we offer IP audits to see what IP you're generating, what you already have generated, and how we can kind of protect that, what the most cost-effective way to do that is. Put together some sort of strategy. Think about what your competitors are doing and how you might enforce your rights against them if you want to, how you might license your rights. And also, something to consider is what rights your competitors have which might prevent you from doing what you want, so your freedom to operate. And that's something to consider. So that's pretty much all I had to say. Come and see us on stand 2414, which is just over there. If you've got any specific questions, I'll be hanging around afterwards, so do come and grab me. But otherwise, thanks for coming.